The hearing will start now. This is originating application 250 of 2023, Zipmex Private Limited. Originating application 251 of 2023, Zipmex Asia Private Limited. Originating application 252 of 2023, Zipmex Australian Proprietary Limited. Originating application 381 of 2022, Zipmex Company Limited. Originating application 382 of 2022, Zipmex Private Limited. Originating application 383 of 2022, Zipmex Asia Private Limited. Originating application 384 of 2022, Zipmex Australia Proprietary Limited. And originating application 385 of 2022, PT Zipmex Exchange Indonesia.
Thank you. Good morning, Mr. Daniel Chia, Mr. Jonathan Tang, and Ms. Charlene Wee for the applicants, correct?
Yes, Your Honor, that's correct.
All right, thank you. We have a bit of feedback. Morgan Lewis is still on record?
Yes, I can.
All right, thank you. All right, let me administer the Zoom allocation. Parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, Mr. Chia, thank you for sending in your submissions earlier. You can perhaps at this point summarize your application and the main grounds underlying it, please. Thank you.
Yes, Your Honor.
Oh, sorry. Perhaps I don't know whether one of your colleagues might want to switch on their microphone. That might help. A bit of feedback. So let's try again, Mr. Chia.
Yes, Your Honor. Can you?
Yeah. All right, there's a little bit, but never mind. Let's try to switch you on. Thank you.
Is Your Honor able to hear me? Okay. Give me one moment.
No, it's a bit of an echo.
Yeah, Your Honor, can you hear me now?
Yes, a little bit of echo, but not totally unintelligible. Let's try to proceed.
Thank you, Your Honor. Your Honor, we propose to actually deal with it in this way. Let me first set out the outline of what we want to do. The first one is, Your Honor has before you the sanction applications as defined in our written submissions. And we intend to go through the law and the main points, as well as why we have met all those criteria. As part of that consideration, Your Honor, we invite on to vote on whether an administrative class should actually be created.
Sorry. Yeah. I think there is a bit of an echo. I think maybe the audience may also find it difficult. Perhaps what we could do, let's stand down for a few minutes and we try to sort this out, and then we'll resume after.
Yes, Your Honor.
All right. All right, Annie? All right. We'll stand down for a minute. Thank you.
Hearing will resume now.
All right, thank you. Let's try again. Mr. Sorry, Chair, we were about to go into this section application.
Yes, Your Honor. I apologize for the audio issues on my end. Let me pick up from where I was talking about. I said that I wanted to split today into, I think, what we see are four main areas. The first area is the sanction issues, as well as if the criteria for sanction is met. And with that also is the second related issue of whether an administrative class should be recognized. For those main issues, Your Honor, I propose for Mr. Jonathan Tang to address Your Honor on the law and the criteria. And of course, I stand ready to assist in respect of any questions Your Honor may have.
All right.
Your Honor will then have to maybe other questions about the scheme in general, which depending on the issue, both Mr. Tang and I will try to address Your Honor to clear up any kind of misunderstanding in respect of our submissions. And finally, depending on the outcome of today, Your Honor, there are also the moratorium extension applications that we are seeking for 3 weeks. And those are the subject matters of summons 754 through to 758.
All right, thank you, Mr. Chair. We can proceed accordingly. For those observing, for the creditors observing, I will give a summary at the end of the submissions to indicate where we are. And at that point, I will see if there are any objections or concerns. Right, thank you. Let's proceed then. Sorry, who's taking the next one?
I'm passing it over to Mr. Tang right now.
All right, Mr. Tang. All right, thank you.
Your Honor, may you please afford? As Mr. Chia had introduced, there are 3 sanction applications in OAs 250, 251, and 252. And there are 5 extension of moratorium applications in Summon 754 to 758. Your Honor, maybe preliminarily, there is a small matter of housekeeping in that we had submitted 3 hard copy bundles to the court, and just to confirm that these bundles have been received, Your Honor. They are a bundle of joint written submissions, a joint bundle of documents, and a joint bundle of authorities, all bound in red.
All right, thank you. Yes.
Thank you, Your Honor. As is Your Honor's custom, we assume that the submissions have been read,
Yes.
and we'll proceed accordingly. Grateful, Your Honor. In terms of the sanction applications itself, perhaps what we can do is to deal with OAs 250 and 252 first, because these are the multi-class prepackaged schemes of arrangement. And then after that, we deal with 251, which is only 1 class.
Yes.
So, yes, Your Honor. Perhaps if I can take the court through the timeline, that might be helpful.
Yes.
And this is paragraph 8 of our written submissions. There is a table there, Your Honor, which starts at 6 February 2023. I do want to bring the court's recollection back maybe to 2nd December, which was the extension hearing. Following that, on 6 February 2023, the scheme documents for all 3 of the schemes were dispatched to creditors. 14 to 15 days were provided for lodgement of proof of debts. So that's 21st February. On 6th of March, the scheme managers wrote to each of the sanctioned applicant scheme creditors to inform them of the outcome of the adjudication. Following that, 7 days later, because there was no objection to the adjudication, we informed scheme creditors of the outcome of the vote solicitation. And then on 17 March, the sanction applications were filed. On 24th March, we had published the advertisements in the BT and the Gazette. And on 27 March, we lodged them with ACRA, Your Honor. So when it comes to the 2 exchange companies, what has happened was that we had split the creditors into 2 classes. For ease of reference, perhaps I can call them the customer creditor class and the vendor creditor class. The customer creditor class, Your Honor, is comprised of individuals who are customers of the 2 exchanges. In total, we have around 70,000 creditors who fall within this class. The vendor creditor class is substantially smaller. Those are the vendors who provide essential services and continuing services to the companies. In respect of the terms of the scheme, the customer creditor class is intended to be compromised by giving them access back to the assets that have been held up in the Z wallet so far. As Your Honor recalls, on or around July 2022, the 4 exchanges in OAs 381 to 385 suspended withdrawals from the Z wallet. So we have termed this in the submissions and in the affidavits as the withheld assets. And essentially what has happened since then is that digital currency for 4 main coins, BTC, ETH, USDC, and USDT, have been held in lockup in the Z wallets since the commencement of the moratorium application. What the schemes aim to do is to give customer creditors back the access to these particular coins so that they can withdraw them at a certain date following the completion of the investment. In terms of quantum, what we are talking about for Zipmex Private Limited is around a sum of USD 87.4 million. For Australia, we are talking about USD 1.37 or 38 million in terms of value of these digital assets. Following the initial moratorium application, What then happened was an investor expressed a very concrete interest in rescuing the company. Your Honor will recall that on 30th November, an investment agreement, for reference, I'll just call it the SSA, was signed between Zipmex Asia, the holdco, and this investor. The terms of this agreement was basically that the investor would, at the completion of the investment, put in a sum of money and a sum of digital currency that would restore the group's holdings to pre-insolvency event levels. Right? So basically the position that was before July 2022. In the meantime, periodic payments would be made to the group to allow them to continue operating, basically to keep the lights on, Your Honor. These periodic payments are subject to the super priority order that was made by Your Honor at the end of December 22. So that's the plan for customer creditors in a nutshell. Once the investment is complete, the schemes are sanctioned and the schemes are implemented. The customer creditors will, within 30 days, receive access to these withheld assets in the Z wallets. For vendor creditors, the plan is much simpler. We intend to pay them back 100% of their debts in full within 30 days of the completion of the investment and the implementation of the scheme. Your Honor, if I may. I would like then to turn the court's attention to the voting totals. And this is at page 8 of our written submissions, paragraph 11. Yes. And Your Honor will see that we have set out 3 tables there between pages 8, 9, and 10 of our submissions. For Zipmex Singapore, Your Honor, is table 2. Your Honor has seen that we have split it into the customer creditor and the vendor creditor class. The results are evident, Your Honor. In terms of number, we have 1,299 creditors in the customer creditor class voting in favor. 6 creditors have objected. The percentage is 99.51% in favor, representing 99.78% of value present and voting for this particular class. In other words, participating in the prepackaged scheme for this particular class. For the vendor creditor class, we have 100% both in number and value who have approved the terms of the prepackaged scheme. At table 3, we see Zipmex Australia. There were less participants in this particular class. 12 customer creditors have voted in favor. 1 has voted against. That brings us to 92.31% in number voting in favor. The sole creditor voting against has a value of less than $1 USD in holding, Your Honor. So in terms of value, effectively, it's 100% voting in favor and 0% voting against. For the vendor creditor class, like Zipmex Private Limited, the Australian entity has had 100% voting in favor in both number and value for the terms of the prepackaged scheme. For Zipmex Asia and for completeness, there's only 1 class and it's all vendors. Again, for Zipmex Asia, we have 100% in value and number voting in favor of Zipmex Asia's prepackaged scheme. So that brings us to that concludes the overview of the vote solicitation totals. Now, if it pleases the court, perhaps what may assist the court is if I go into a little bit of a discussion about how we have classified the creditors for the purposes of Zipmex Private Limited and Zipmex Australia. Yes. So, Your Honor, again, to cast the court's mind back, we had 70,000 creditors when we first commenced this exercise. These 70,000 span a wide range of voting values. Essentially, their holdings in the Z wallet range from up to a few million USD worth to creditors who maybe had quite negligible holdings in the Z wallet. The approach we had taken to assist the administration of a prepackaged scheme is to classify these creditors or customer creditors into two separate bands. And for that, we use a threshold value of USD 5,000. So the approach we had taken was that for creditors who are above or whose holdings are above USD 5,000 in indicative value, we would be seeking their participation in the voting exercise for the scheme of arrangement for both Zipmex Pte Ltd and Zipmex Australia. On the other hand, for creditors whose indicative value of their holdings was below USD 5,000, we took the approach that they would be bound by the terms of the schemes, but there was no necessity for them to participate in the voting solicitation exercise. In other words, Your Honor, the administrative convenience class that we have first proposed at the hearing on 2nd December 2022. Following that hearing, and of course, Your Honor's observations on the propriety perhaps of the creation of such a class, what we did was that we still pressed on with this particular band of classification, because as Your Honor will appreciate, 70,000 is a very unwieldy number for a scheme manager to try and adjudicate in a prepackaged scheme. But we did that with one important difference, Your Honor. The important difference is that regardless of our intention that they be counted as voting in favor, even though they did not participate in the schemes, we actually sent the scheme documents to every single creditor in the class, or every single customer creditor known to the companies, and we invited them to vote if they wanted to. In other words, they were given copies of the explanatory statement and the scheme of arrangement, and they were given instructions on how to participate in the electronic voting process. So where we've landed on that is that the vote solicitation totals that I brought the court's attention to earlier actually included the votes from members of this particular class whose holdings were less than USD 5,000. And maybe this would be a good juncture, Your Honor, for me to bring the court to a few other tables that we had actually included in the submissions. And for this, Your Honor, perhaps I could turn the court's attention to paragraph 41 of my written submissions. So that's at page 21 and overleaf page 22. Thank you, Your Honor. For Zipmex Private Limited, Your Honor, what we did and the exercise that we had actually carried out was to split the previous vote totals into those members who had voted who were not within this proposed class. And then we had a separate table showing how the members in this particular class voted. And Your Honor will see that at page 22. In terms of number, it was surprising to us that the majority of the customer creditors that actually made an effort to participate in the vote solicitation actually came from within the proposed class. But Your Honor will see that within the class itself, there is a level of support, an overwhelming, we say, level of support for the terms of the scheme. So when it is distilled down to the members of this proposed class who had voted, we see 882 votes in favor of the terms, 3 votes against. That brings us to a 99.66% in number and a 99.99% in value of members of the class who had approved the terms of the prepackaged scheme. The position is very similar for Australia, and that is paragraph 44, the next 23 of the written submissions. You will see, Your Honor, that there were 9 votes in favor one vote against. The vote against has an indicative value in holding of less than $1 USD. So that brings us to 90% in number voting in favor and 100% in value voting in favor. And I bring the court's attention to this simply to show that even if the class was not created, or we had not proposed to do this in this manner, nonetheless, the majority of creditors, or the statutory majority at least, would have approved the terms of the prepackaged scheme for the customer creditor class in Zipmex Private Limited and Zipmex Australia. Maybe I should pause here, Your Honor, to ask if the court has any questions. Thank you, Your Honor. Would Your Honor wish that we go into a bit of an exposition on the pre-code cases? Because we do recall that this was something that
yes, but perhaps you could go into the any other matters relating to the voting and all that. We'll take the legal arguments towards the end.
Yes, Your Honor. Well, in terms of the matters that we need to satisfy in regards of sanction, from DSG, we understand, Your Honor, that there are three main areas that the court will be concerned about. The first is classification of creditors and the dissimilarity principle, which I have addressed. The second is the disclosure requirements, which I will now address. And the third is statutory majority, which we have shown, Your Honor. So in terms of disclosure, perhaps I can turn the court again to paragraph 23 onwards, and that is page 13 and 14 of the written submissions. Yes. So Your Honor has seen there that we have set out in the affidavits and in the written submissions exactly which paragraphs of the explanatory statement and the scheme have been or rather fulfill the disclosure requirements that are required by section 71 subsection 3(1)(a) of the ERDA, Your Honor. And I don't propose to go into detail on this, but we have done that exercise at paragraph 23, 24, and 25 for Zipmex Private Limited, Zipmex Asia, and Zipmex Australia, respectively. On this, perhaps I also want to emphasize one point, Your Honor. We are aware, and the companies are aware, that for Zipmex Singapore, a large portion of their customer creditor base is based in Thailand. And in order to ensure that they have access to all this information, what the company has done is every email that has been sent out has been translated into the Thai language. The scheme document and the explanatory statement have been translated into the Thai language. And Your Honor will see in the affidavit that when we dispatched the scheme documents to customer creditors, it was the English version first, and then the Thai version annexed behind. All the announcements on the website have been posted both in English and in Thai, right? And that is, or those are the additional steps that the company has taken to ensure that all customer creditors who may be affected by the schemes of arrangement have received sufficient information and disclosure to enable them to make an informed choice on the voting process should they have chosen to participate. Your Honor, the third criteria in DSG was statutory majority. I don't think Your Honor would need me to expand further on that. We have seen the vote totals, Your Honor. Yes, in relation to the sanction applications, unless I may assist the court any further, that is, those are my substantive submissions, and perhaps we, if the court would like me to address the court on the legal basis for.
The extension of Thai moratorium applications will just flow through from sanction applications, correct?
Yes.
Could you just at this point indicate to me the basis for the extension required?
I beg your pardon, Your Honor?
Could you indicate to me the basis for the extensions required? Why 3 weeks? Or was it 3 weeks? Yeah.
Yes, Your Honor. We're asking for 3 weeks for all of the 5 companies. For the 3 companies who are the applicants in the sanction applications, we have asked for 3 weeks to give us a buffer to conduct the post-sanction administrative requirements. Those involve the extraction of the orders of court, the lodgement of the orders of court with ACRA, in order for the scheme to take effect. For all 5 companies generally, the sanction of the schemes is a condition precedent for the completion of the investment. This is a group restructuring whereby the investor is envisaged to put the assets and the money into Zipmex Asia, and then it's downstream to the other entities in the group for their operating expenses, etc. We are asking for 3 weeks for all the companies in order for us to complete the investment and give us sufficient buffer while under the court supervised moratorium to do all things necessary in order to effect the completion of the investment by the investor.
All right, thank you. All right, now turning to the question of the administrative class, thank you for sending in a submission. So my concern is primarily about the ability of the court to adopt a similar approach to the US courts. So it's less about the express statutory provision present in the bankruptcy code and more about the kind of approach adopted by the court pre-code. And perhaps then you could submit to me how you see a Singapore court actually applying or implementing something similar.
Yes, Your Honor. Our submissions had actually focused on the pre-code practice, and this was driven by comments Your Honor had made at the 2nd December hearing where we had sought the court's approval for the creation of this class. So following that, in the 4 months interim, what we had done was looked at pre-code cases as well as the jurisprudence surrounding the enactment of the code in 1978. And perhaps the first port of call, Your Honor, is to look at what the US Senate and the US House actually said about the enactment of the code and this particular provision. And for that, Your Honor, I would have to turn the court's attention to the bundle of authorities, which is a thicker bundle.
Yes.
So if Your Honor can look at page 517 on the top right-hand side of the bundle of authorities. This lengthy document, Your Honor, is the House report prior to the enactment of the code. And when we look at the commentary on section 1122, down the page, the second last paragraph from the bottom, subsection B, also a codification of existing practice, contains an exception. The plan may designate a separate class of claims consisting only of every unsecured claim that is less than or reduced to an amount that the court approves as reasonable and necessary for administrative convenience. And I want to focus here on codification of existing practice, Your Honor. Even before the code was enacted, in reorganizations, the US courts had taken the approach that the creation of such a class could be done. So that is a House report, Your Honor. Now we look at the Senate Judiciary Committee report, and that will be page 809 of the same bundle. So Your Honor, is Your Honor there? Yes. So Your Honor will see in the Senate report that the same language exists, right? It basically echoes a House report. Subsection B is also a codification of existing practice, contains an exception. The plan may designate a separate class, etc., for administrative convenience. And it's not just the two reports, Your Honor, that show this. We've also taken a look at some pre-code cases. Those were set out in my submissions, but perhaps what could be of value is I think the court to two cases that we have identified as being particularly illustrative or relevant. So the first case, Your Honor, is the Keach case, which is Cap 8 of our bundle of authorities. So both these cases are relatively short judgments, but we feel that they illustrate how reorganizations were treated prior to the code coming into effect. So this is a 1913 case, comparatively ancient. And Your Honor will see right on the first page, on the right-hand column, the second side, Your Honor will see in the second paragraph that this involved a plan whereby general creditors holding claims of $100 or under were to receive 100% in cash. Claims of over $100 were to be paid 50% in cash, right? And this is illustrative that even in 1913, Your Honor, there was this approach that allowed for varying payouts for small creditors to be paid in full, which this plan shows, Your Honor. The second case I probably wish to take the court to is the Realty Associates case, which is at tab 13 of our bundle of authorities. We're looking at page.
Hold on a moment, please, Mr. Tang. Let me just read through Teach again. Give me a moment.
Yes, Your Honor.
The thing is about Teach, it seems to have created that class of these classes, but is there any statement in the case that goes into the propriety or the fairness of the administrative convenience clause as such?
No, Your Honor. And the reason for that is that in the prior cases, there was no, they wouldn't have used the term administrative convenience or convenience, because that was something that was enacted in the code. Yeah. So it was more a case of showing the court, and this is what we have attempted to show, that prior to the code being enacted, there was a practice whereby smaller claims may be paid in full and compromised without the necessity of having them vote.
All right, where do you get that from, Keach, please?
The illustration would be the terms of the plan itself, Your Honor, which I have brought the court to, where general creditors holding claims of $100 or under were to receive 100% in cash.
Without voting, where do you get the point that they didn't have to vote?
It is not in the case itself, but it was more, we had raised this case, Your Honor, in an attempt to show the court that there was a practice of splitting various claims into this particular in this particular kind of situation, whereby smaller creditors could be paid in full. But nonetheless, Your Honor, perhaps if I could move just to Realty.
All right.
Yeah, which is chapter 13 of the bundle of authorities.
Yes.
So Realty is a wartime case, right? And the issue in Realty was really whether or not vendors providing critical services who were very difficult to replace could be paid in full in the course of the reorganization. And I'm looking at page 88, Your Honor, in paragraph 1, where the sentence starts, it might be difficult. It might be difficult, if not impossible, to obtain contractors to do the necessary, and it would be far better to pay the small sums that are due these creditors in order to encourage them to do the necessary work to keep and repair the debtor's property. The conclusion seems inescapable that it is highly desirable that these payments be made, as it will materially aid the proper administration of the estate. At paragraph 2 and 3, it is the established practice to make payment to small claimants. Such discrimination is permissible. And again, Your Honor, this is a 1943 case, free code, whereby the court had, or the US bankruptcy court at the time, had approved payments out to smaller creditors. Of course, in this case, there may have been extenuating circumstances in that it was wartime. but nonetheless, this is a practice that was established pre-code.
Right. So again, I'm not sure how useful this is because it does seem to be concerned with the propriety of paying out small creditors, which we have, as you have noted, encouraged locally as well. But I think I'm more concerned about whether there's any pre-code case that would actually say that a deeming of removing the vote would be appropriate.
No, Your Honor. Unfortunately, in the course of our research so far, we have not been able to find a case that specifically says that. But for the purposes of this particular argument, Your Honor, I would like to show the court that time-wise, previously, pre-code, there was this practice, right? In the code itself, when it was enacted, Section 1122B specifically made an administrative convenience class possible. And in doing so, both the Senate and the House highlighted that it codified existing practice. Prior to the code being put into effect, Your Honor, it is unlikely, we say, that the past cases would have looked at the question of administrative convenience, etc. But it was very clear in the lawmaker's mind in 1978 that this was to help administrators and to assist reorganization plans in order to reduce the burden of administrative convenience. And perhaps for that, if I can turn the court back to our written submissions. Right, I'm looking at paragraph 51, and now we're looking at post-code cases, Your Honor. So at paragraph 51 and 52, we have extracted excerpts from two cases, Re-S&W Enterprise and Re-Novinda Corp. And at paragraph 51, the italicized words are persuasive, Your Honor, where Section 1122B, the effect was described by the court as helping to weed out numerous claims and thereby avoid administrative costs. In terms of S&W Enterprise, this was a case where the court cautioned against gerrymandering of votes, whereby the court cautioned that this provision should not be used in order to obtain a more favorable vote on the scheme by excluding creditors that might vote against it. In our cases, Your Honor, this is not the case. As I have shown the court earlier, even if the administrative class were to be counted separately, these creditors would have still voted in favor of the terms of the prepackaged schemes. At paragraph 52, we see Novinda Corp. And this distills in essence the purpose of 1122B. A separate class would be beneficial to the estate if for no other reason than to eliminate meddlesome interference absorbing the plan administrator's time. So in terms of time, we appreciate that pre-code, there would not have been a single case or any combination of cases that may have set out the principle that this was for convenience. But it is clear to us, we say, that in enacting the code and this particular provision, the US lawmakers intended very clearly to codify the practice for the purposes of administrative convenience. And then following that, the cases show the application of the section is to, in fact, eliminate and reduce the administrative burden on organizers of the estate and administrators of the restructuring plan.
All right. Do you have any cases, whether post or pre-code, that really go into the question of whether it's appropriate to remove the vote from this class or to deem approval for this class?
On a post-code, we wouldn't need to do that. Well, No, Your Honor, because they'll be paid in full.
All right.
Yeah, which is also the case here, whereby the creditors will receive the same benefits that even those creditors who are not in the class will be receiving under the terms of the schemes.
All right. So basically, the quid pro quo for not getting a vote is that you'll be paid in full, and no prejudice would be suffered.
Yes, Your Honor, and perhaps we would emphasize that in this case, we are not asking them, or we are not saying that they cannot vote. We are saying that unless you participate and vote no, you are taken to have abstained or voted yes, or you will be in favor. But nonetheless, please come if you wish to vote no. We wish to have your voice heard and we will count them in the totals. We did the exercise, and as it turns out, the votes have fallen the way they have for both the main class in total and for members of the class that we are designated as administrative convenience as well.
All right. All right, but that's really the plank of your arguments here, that there's no prejudice suffered by this administrative convenience class.
Yes, Your Honor. Your Honor, perhaps Mr. Chia can, or rather perhaps Mr. Chia can address the court further on this particular point, Your Honor.
All right, thank you. Mr. Chia.
Yes, Your Honor. Your Honor, I think the additional point that I wanted to suggest to Your Honor is this. It's that really, although the historical treatment of the creation of an administrative class is actually to help the administration of the scheme and the restructuring, in our particular case, what has also happened is it's made it easier for some of these customer creditors to, in a way, participate and have their votes heard. So the way how we see that has developed is that we have told these customer creditors that they do have a right to vote, and they would in a way be deemed to either abstain or to agree to the particular scheme unless they want to voice objection to it. In this way, these creditors don't actually have to log in. They don't actually have to look at the online voting and actually vote. It's made it easier for them. And that is the other purpose for why we say that there is no prejudice in this particular case. And that was the additional point that I just wanted to make in respect of how we have gone about dealing with this administrative class. All
right, thank you, Mr. Chair. Now, the next question, of course, is how do I import this into our law? Mr. Tang or Mr. Chia, I'm not sure that I'll be able to do so under the rules of court. That would be primarily procedural, and I don't think these are matters that fall under the civil procedure rules as such, and I don't think that any lacuna can be filled in by Order 3. So you referred to Section 6. Arda, could you expand on that? How does that help me?
Your Honor, if I may, Mr. Chair has passed it back to me to answer these questions about jurisdiction.
All right.
Right. So Your Honor has mentioned our reference to Section 6 of the ERDA. And Your Honor, just turning to Section 6 itself, this is at tab 3 of the VOA. So the discussion about classification, at least from the authorities, ranging from TT International to Bright Oil and DSG, Your Honor, in 2022, was focused on the dissimilarity principle and also focused on the court's approval of a scheme of arrangement under Section 212 of the Companies Act, which still exists today. We say that this is similar to Section 71, subsection 1 to 3 of the ERDA. The court still has to approve the prepackaged scheme of arrangement. When it comes to Section 6, Your Honor, we focus on the last part of Section 6(1) of the Act. So the court, when exercising its jurisdiction, has full power to decide all questions of priorities and all other questions going to the end, or that the court considers expedient necessary to decide for the purpose of doing complete justice or making a complete distribution of property in any such case or matter. And we say that in terms of the creation of a class, perhaps the phrase complete distribution of property might be more relevant in this particular instance. But nonetheless, the overarching power conferred by Section 6 of the ERDA should or can apply to the court's ability to make a decision on whether the creation of this administrative convenience class be approved in this particular circumstance when it comes to Zipmex Private Limited and Zipmex Australia.
All right. Thank you. Anything else, Mr. Chair? Sorry, Mr. Tang.
Nothing from me, or unless I may be of any further assistance, those are my submissions.
All right, thank you. All right, let me then turn to those who may be watching and present. So basically, what is happening today is that the applicant companies are asking for court to approve what is known as a pre-package arrangement, in which the scheme is approved without meeting. Under our law, under the Insolvency Restructuring and Dissolution Act, they're allowed to do so in some circumstances. And basically, in my previous case in DSG, I highlighted the need for proper disclosure of information, as well as proper ticking of the indications of approval of voting by the company. So in this situation, they can get around the need to have a meeting. They'll use what we call pre-pack. Those requirements, they say, for disclosure and for the majority requirements, they say have been met. So that's one issue. They say that the voting that they've recorded does show overwhelming support for the prepackaged plans, and that the opposition is very low and doesn't meet the threshold for rejection. The second main point this morning is the use of the administrative convenience clause. This is something taken from American law. There is a specific provision now in the US Bankruptcy Court allowing for the creation of an administrative convenience clause. I had dealt with this previously at a previous hearing, and I had issued grounds indicating that at that time I thought it was premature for me to express a view. But this is now the time for me to face the question head on. And the applicants argued that the position in the United States, even before the enactment of the bankruptcy code, shows that the administrative convenience clause was, its equivalent was in use in the US and approved by the courts. I have some reservations about some of the cases cited, but I would not reject their position straight out of hand. And also, I would note that there might be some room under our ERDA for me to adopt something similar to the US approach. So that's my tentative view. What I would like to do at this time is to see whether anyone present would like to state any objection to the application for approval, as well as for the extension of the moratorium. And just to round it off, they are applying for an extension moratorium for 3 weeks so that they can get through the administrative measures, supposing I approve the application this morning. So they need about 3 weeks to implement it. Right, so could I see, and my manager will help me keep track of whether there's anyone who wishes to express any objection. Any? Let's see. One hand raised. All right. Who is that, please? I think
It's a Navita Dagut.
all right. All right.
May I support him?
Yes.
I'm afraid that he has declined to be promoted to a panel.
All right, so let me change the mind. Anyone else?
No one else.
No one else. All right. All right. In that case, then, let me just stand down a few minutes. I wish to go through the submissions and the papers again, probably about half an hour. I just want to make sure that everything is in order before I get my decision this morning. All right. So any will adjourn for 30 minutes. Oh, sorry. Does Mr. Takut wish to say anything?
Let me try again.
All right. Right, Mr. Direkut, did you wish to say something in objection or opposition? Sorry, Mr. Direkut, your audio is off.
Good morning, Your Honor. Can you hear me?
Yes, thank you. Yes,
Your
Mr.
Honor, I would like to bring to your attention a recent published article on Bloomberg on the 24th of March last week.
Mhm.
In the article, it stated that the investors in Zipmex has bailed out, that made a default on payments,
Mhm.
which was due in February and a deadline on the 23rd of March. They didn't make that payment.
Yeah, mhm.
And apparently Zipmex would have to close down certain part of their operation branches in order to cover up the operational costs.
Mhm.
Zipmex has clarified and has confirmed to that article, and there were no payments made for operational costs of over $1 million to Zipmex. And that particular detail of the default payment has been made to you by Jonathan and Zipmex on the 27th of March, 2 days ago, in that affidavit they submitted to the Supreme Court of Singapore.
Mhm.
Bearing that in mind, there are grave concerns to customers of Zipmex, which are now the creditors, that whether or not this particular SSA agreement of the investors will eventually go through.
Mhm.
It's rather grim, as Zipmex has clarified that they were unable to contact investors themselves, and there are no communications between the two. If the investors have bailed out on $1 million for operational costs, the whole $100 million that are supposedly going to go through in the next 30 days seems quite grim. I did vote in favor of the scheme. I have no objections with the scheme. After all, I want my money back. I'm not a lawyer, so I'll say this in layman terms, Your Honor. Customers or creditors in Thailand would need your guidance. Once this moratorium has ended in the next 3 weeks, the legal battles are all tangled up because we're now up in Zipmex, which have subsidizes their assets in Zipmex Singapore. We're now up in your court. So in the next 3 weeks that the moratorium has ended, we need your guidance on how we're going to go through in terms of legal matters. Thank you very much, Your Honor. I have no objections with the SSA. I have no objections with the scheme. I vote in favor, but I just want to bring this grave concern to you, Your Honor. Thank you.
Thank you, Mr. Woods. Hold on a moment, please. Let me turn back to, was it Mr. Chia? Do you wish to respond?
Yes, Your Honor. I think Your Honor, the news reports it is what it is. However, the SSA currently is still alive. One of the CPs, I think, as stated in also the affidavits, is that we need to get this scheme sanctioned in order for there to be a chance for the completion of the investment. And that's really what we are trying to do. At the end of the day, whatever way this games out, it is not going to be a situation where if the scheme is sanctioned, immediately the customer creditors take a write down on their original asset, and therefore we're looking at a lower amount for them. If it doesn't go through and if it fails to be implemented for whatever reason, Your Honor, we go back to status quo. What we are really asking the court today is to give us a chance, and of course with the support of the creditors of the company, to give us a chance to ensure that this completes and we can then give the creditors back whatever is due to them, and as well as to fulfill the terms of the scheme. And that really is the sole consideration. Thank you, Your Honor.
All right, but Mr. Chair, I think the concern is this going to happen at all in the next 30 days? Is this going to lead to nowhere?
Yes. Well, Your Honor, I hear that concern. The truth is that, the way how these investments are, it is complex in the sense that there are certain things that both the company and the investor has to do, which we are working through. Currently, all I can tell you is that the investment is still alive, the contract is still alive, and yes, we have to complete it. Some of the CPs can be waived, some may be waived eventually.
Sorry, waiver of the?
Some of the condition precedents can and may be waived by either party in order to get this through. But what is important, which I must stress, is that the sanction of the scheme is also one of the condition precedents.
All right. Could I ask you then point blank, Mr. Chair, is your client still in contact with the investor?
There are still communications that are going. And I know that the last communication related to the tranche 4 payment and the discussion about the tranche 4 payment. So that's what I know, Your Honor. But how exactly what they were talking about or what, that is really something that the deal team is doing. I'm not really involved in that at this point in time.
All right, so that gives me some point of concern. As Mr. Tirico himself said, he's not opposing it, and I don't think anyone else is opposing. But it does give rise to concern. So I don't want after today that everyone goes away thinking everything is hunky-dory, and then a few weeks later, we find out from Bloomberg or Jetwire or someone else that things are going belly up. I may need to intervene a bit more, Mr. Chia, all right? Unless you can give me an assurance right now. There is full communications between Zipmex and the investor.
Your Honor, yes. No, Your Honor, the only assurance I can give, sadly, is the fact that I do know that there was discussions in respect to the tranche 4 payment. It's not a situation where everybody has been ghosted. I do understand that there are also official channels and notice provisions, and that as of the current date, there has been the SSA is still alive. As early as or as late as yesterday, there was a letter that we received from the investors' lawyers about some of the CPs, which we will have to work through. Yes, so those are the communications. So it's not that the investor has disappeared and gone fly by night. That's not what has happened.
All right, so Mr. Derrick, the position appears to be that Zipmex has not been ghosted by the investor. There might be some, I suspect, modification of some of the conditions leading up to the agreement. But Mr. Chair seems to be saying that they hope to get the sanctions so that the agreement as a whole can go through and everyone can get the money back. That's the position, Mr. Chair?
Yes, Your Honor, we're trying to work it through, and understandably, the sanction itself is going to help to show the investor that we are what an important CP has been.
All right. All right. So, Mr. Jericho, what I can do at this point is to require the lawyers here to update me, say in about 2 weeks' time, about where things are, and if things are going belly up, then I will have to call everyone back at that point, and we'll see what can be done. All right. But otherwise, that's what they can say at the time.
Thank you very much.
All right. In terms of the moratoria, basically after the moratoria is lifted or expires in 3 weeks' time, any proceedings can take place. If any creditors can try to file proceedings in Singapore against the company, but if they are part of the scheme, then that would normally preclude them from taking any action, because otherwise there'll be a breach of the scheme terms. Someone else who's not creditor, for example, is not covered by scheme, may be able to proceed with their application to court, but I would assume that given the structure of what the plan they come up with, there hopefully should not be anyone in that boat who can sue the company for a large amount. But that's
Thank you very much, Your Honor.
All right. All right. All right. In this case, let me just send off about 50 15, 20 minutes or so, at about 11:25, and I'll go to the papers and give my decision accordingly.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you. Court stands.
Court is adjourned. So resume now.
Progress.
Right. Thank you, everyone. I'll now give my decision. I am satisfied that the requirements under Section 71 of ERDA and the case law governing prepaid arrangements have been met, and the proposed schemes should be approved. I am further persuaded that the court should recognize the use of the administrative convenience clause. I will not expand on legal grounds today, but it is enough to note briefly that I am of the view that is permitted by the provisions of ERDA and the Companies Act. The use of the administrative convenience clause is appropriate where there's a large number of creditors holding relatively small amounts, and the use of actual voting or other usual measures may either be burdensome or hinder an otherwise appropriate scheme. The court will need to determine if any prejudice affects the members of such a class, but here I am satisfied that given the promise of full payment as well as the ability to vote, that there is no such prejudice. I have concerns about the report as recounted by Mr. Dirkwood. I recognize that such investments may be complex affairs. I do not think based on what is before me that sanctions should be withheld, but balancing the interest of those involved, I will, however, require that the applicant's counsel update me and the creditors in 2 weeks' time about the status of the investment in the scheme. Thus, in relation to originating applications 250 to 252 of 2023, I order in terms praise 1, 2, and 3. And in relation to summonses 754, 755, 756, 757, and 758 arising out of the previous OAs, order in terms of praise 1, 2, and 3 as well. As I reiterate, I mentioned earlier, I reiterate a direction is to, I give a direction that letter is to be sent in by the applicant's counsel to the court and creditors updating on the status of investments and the scheme by 13th April 2023, and the court may give directions thereafter. So that is my decision. Anything further, Mr. Chia or Mr. Tang?
Nothing further on our end. Thank you very much.
All right, thank you then. Court is thus adjourned. Good day.
Good day, Yang.
Good day.